The High Court in Pretoria has ruled that President Cyril Ramaphosa's signing of the National Health Insurance Bill in May 2024 is in fact open for review by the courts. The South African Private Practitioners Forum and the Board of Health Funders approached the courts seeking clarity on the rationality and legality of the president's signing of the bill. The groups argued that despite a number of submissions being made to the bill, it was not referred back to Parliament as per Section 79.1 of the Constitution. Let's speak now to Dr. Simon Strachan from the South African Private Practitioners Forum. Dr. Strachan, very good afternoon to you. Thanks very much for your time. A victory for you, at least for now, certainly, isn't it?
Good afternoon, Voyo. Thank you for the opportunity. Yes, indeed. We will celebrate a victory, although understanding that this is the very early start of a process, but a victory nonetheless.
But then, I mean, wasn't it Parliament that had to do the bulk of, public hearings, consultations, debates and everything that goes with piloting any piece of legislation, and perhaps less so the president?
Well, that's an interesting point, because that's exactly part of the discussion that was had during those 2 days that the matter was heard. So the substance of our court action was one on procedural grounds, which you mentioned, where we are questioning the president assenting to the bill, because he has a constitutional obligation to not sign a bill if any section of it is deemed to be unconstitutional. And part of the argument was that because of the constitutional obligation, this should be heard in the Constitutional Court. So that was the first part of what was discussed in court over those 2 days in March. And the argument that was put forward by our senior counsel was that the president forms the end of a process, of a legal process. And there are many players within this legal process, including people like the Parliament and the National Council of Provinces. And therefore, more than just a constitutional obligation, there is a legal obligation as the leader of our country and as the last stop, so to speak, in the legal process, that the president is then at that stage duty-bound to ensure that, to his mind, that there is nothing about the bill. Now, it doesn't have to be the entire bill, just any section of it is unconstitutional. And if he so believes that any section of the bill is unconstitutional, then he must send the bill back to Parliament for revision and deliberation.
And I know this is hypothetical, but if he did indeed look at the bill and was satisfied, rightly or wrongly, it could be argued, but he was satisfied that it would meet constitutional muster, even though you may agree with his decision. And let's just say that his record of the decision shows that. Will that be the end?
So no, that won't be the end, because first of all, as you mentioned, the other part of our request to the court was that the record of decision-making be made available, not just to us, but also to the High Court itself. So the High Court can see what process was followed that led the president to believe that it was acceptable to assent to the bill. So the record will reveal that. To answer your question, if the record and the court decides that the president was well within his rights and there was in fact nothing unconstitutional about the bill, well, the second part of the case is on more of a substantive ground, where we look at various aspects of the bill. And we are testing the court on the constitutionality of the entire bill in terms of constitutionality. Or in our affidavit, we have highlighted certain sections of the bill that would be, let's say, the third tier of our request. If the bill itself is not found unconstitutional, that certain aspects of the bill be found unconstitutional. So if the decision is that the president assenting to the bill, there's nothing wrong with that at the glance of the information that he had at hand, that his decision is not found to be wanting, then the rest of the case around the other elements of the Act now will have to be debated in court.
And the president now has, what, 10 days to,
Yeah.
yes, to do so.
10 days to produce the record, correct.
In the meantime, this is where the matter will stay.
In the meantime, that's where the matter will stay. But I think what's important also just to mention is that, you know, this matter is before the courts. But the other matter is healthcare reform in this country, and that has to continue. And we are participating as SAPPF in every possible avenue open to us to achieve universal quality access for all South Africans through various groups and applying our minds to every possible avenue available to us, because we realize the inequity in this country. And we cannot, as a country, let what is happening in the courts with the NHI Act detract us from every effort to improve healthcare in this country. And that has to be the drive. It's almost like separating the two issues, going, right, we used every opportunity we had to make our voices heard around the NHI bill, which became the Act, and we didn't get anywhere. So we took the only route left to us, which was to go to court to ensure that our patients and our colleagues have a voice and are heard. That's the one side of it. The other side, where we have to work equally hard, if not harder, is to still participate and to strive for health reform.
Well, speaking of perhaps a parting shot, using every opportunity you have outside of litigation, what opportunities do you believe we still have to iron things out and hopefully and ultimately find one another?
So what we've done in the healthcare space is we have formulated a group called the Universal Healthcare Access Coalition. And the founding members of that are my organization, the SAPPF, along with the South African Medical Association and the Progressive Health Forum. And we have developed a proposal for health reform that we have submitted to the President, and that has been forwarded to the Minister of Health. And that was done as early as December 2024. So that's, what, 5-6 months ago. We have, in the last 2 or 3 months, made this publicly available. We have had it on platforms with media. We have had engagements with media on this, and we are now driving this process forward to expand what is at the moment a strategic framework into a more of a policy brief. And we will be reaching out to avenues within Parliament, either Parliament itself or the Health Parliamentary Portfolio Committee on Health, to present this health reform policy to them. And that's part of what we're doing. We are educating healthcare providers in the country around this by holding webinars and ensuring they understand the two-pronged approaches I've suggested to you in terms of one, challenging the Act and other activating health reform. And we have provided this platform open to the entire public to join us in developing the strategic framework into a workable health reform policy for South Africa. And we will continue to engage and continue to talk and make it known to everybody in regulation and in policy formation that healthcare providers are serious about this, that we have a very strong health reform policy and that we need to be heard.
Dr. Strachan, let me thank you for your time. That's why we're going to leave it for today, reacting, of course, to that High Court in Pretoria ruling that President Ramaphosa's signing of the NHI in May is in fact open to a review by the courts. The President has been given 10 days within which to, of course, oblige and do what the court has now asked them to do, which is to produce a record of his decision. How did he come to decide that what Parliament recommended to him is indeed what needs to be done, and that he should go ahead and assent to the bill and sign it off?